And remember, knowledge is power, specifically when your future is on the line. Your asylum can be now denied before you even speak. No hearing, no chance to explain. In April 2025, EOIR just made a big change, and in this video, I will show you exactly how to protect your case before it's too late. If you or someone you know is in removal proceedings, you need to understand this right now. Because the truth is, your entire asylum case might be pre-terminated before you even get the chance to speak to an immigration judge in the courtroom. Here is why this matters. There are nearly 4 million pending asylum cases in the immigration court system right now as of April 2025. The system is overloaded and the judges are overwhelmed with the cases, and the EOIR under the Trump's second administration is under the pressure to move things faster. So now they have decided to give judges more authority to quickly dismiss cases that seems legally insufficient, even if the facts in your case haven't been argued yet. I know this might sound confusing or even unfair, and you're probably wondering, how can they decide an asylum case is invalid if I haven't even testified yet? Don't worry, I'm gonna break it down all for you so you know what exactly really happening right now, how it could affect you or someone you may know, and what steps to take. You are not powerless in this process. You're the one who can protect your immigration case, advocate for yourself, and stay informed when changes like this happen. That's why I made this video for you. Whether you're an asylum applicant or someone who knew an asylum applicant in the United States, you deserve to know what this policy means and what you can do about it. By the way, if you're new here, my name is Abanob. I'm a foreign attorney with a master's degree in US law, and I am currently the founder of VIB US Immigration, a paralegal service provider for immigration attorneys inside the United States. I've seen firsthand how changes in policy can completely shift the outcome of a case. I've read every page of this EOIR memo, and today I'm going to explain it to you without legal jargon, in plain English, so you know what to expect. I know my English might not be perfect because it's not my first language, but I choose to make these videos in English because I want to reach and help as many people as possible. So if you're okay with that, thank you. Now let's get into it. Part 1. What is the pre-remission? Let's start with the basics. Pre-remission means the judge can deny your asylum application, without holding a hearing for you if they believe your application is legally insufficient. It doesn't mean they don't believe in your story, it means your asylum application on paper doesn't meet the legal standard requirement of the United States law. So instead of scheduling a full hearing, the judge can just say, this doesn't qualify for asylum, case closed. Sounds intense, right? Part 2. What changed under this memo? The EOIR memo encourages immigration judges to pre-terminate asylum applications that lack prima facie eligibility, meaning if the applicant didn't clearly meet the basic legal standard from the beginning, their case can be denied right away. Before, there was confusion about whether asylum claims could be denied without a hearing, and now it's very clear. The memo makes it very clear. Right now, immigration judge should do it more often nowadays. And also, they are allowed to do this even if you have never ever been testified before. But why all of that? This is because the regulation at the 8 CFR section 1240.11c3 says that hearings are only required when there are factual disputes. If your story isn't being challenged, just your legal eligibility, no hearing is required. That's their interpretation. Last but not least, what are examples of legally insufficient applications? And listen carefully, very carefully here. This is very crucial. Some of the reasons a judge might pre-terminate your asylum case are whether it was filed too late, past the 1-year deadline without a valid cause, or there is no clear connection to a protected ground like race, religion, or political opinion, or even you have a disqualifying conviction under the immigration law. These issues don't require witnesses or fact-finding. They are legal hurdles that can stop your case cold. In that memo, they even cite court cases to support their memo. So if your application is legally incomplete and is not just a missing document or unclear story, the judge might say no hearing needed, this case ends here. Now the real question is, what if you think the judge is wrong? Can you challenge the pre-remission, or even can you get another chance or a second chance to be heard in the courtroom? We will get to that, but first let's talk about what you can do right now to avoid the pre-remission in the first place. If you're applying for asylum, you need to make your legal argument clear and strong from the very beginning. Your application isn't just about telling your story, it's about proving you meet all the legal requirements for asylum on paper, and here is where immigration attorneys come in. Because if your application doesn't check all the right boxes up front, you may never get your day in the court. This memo is a wake-up call for anyone involved in this asylum process. And if you're already in the proceedings, this could affect you as well immediately. So what you should do next? First and foremost, you need to review your asylum application very carefully, especially if you're past the deadline, the 1-year deadline, or unsure about your eligibility. Second, and this is my advice to everyone of all times, you must work with an experienced immigration attorney or immigration law firm to make sure your case is legally solid. And third, watch my next video where I break down how to strengthen your asylum application and avoid the most common mistakes people make. If you find this video helpful, subscribe now so you don't miss my next video. My goal is to make this channel your go-to source for real immigration updates that could change your life in the United States. Thank you for watching, and I will see you in the next video. And remember, knowledge is power, specifically when your future is on the line.